Good afternoon. I'm David Salyer. I thank y'all for not booing me when I came up, particularly after Renee got you all riled up. I love Renee. I've known her for quite a while now. I've been outside defense counsel for Texas Windstorm for almost 13 years now, and I've tried several cases in some tough venues. I've tried them in Beaumont for Judge Sanderson, Galveston, Corpus Christi, a couple cases in Brownsville against the lawyer who's currently the mayor. And I can honestly say every time I've stood before a jury, I've said that I'm proud to represent Texas Windstorm, and I am. But I'll tell you, the feeling is somewhat like it was when I walked up here, when I approached during voir dire, and I'm about to tell them who I am and who I represent. And I'm worried that they're going to boo and they're going to hiss. And when I tell them I represent Texas Windstorm, you can see a visceral reaction on the face of some of them. And when I picked a jury in Corpus Christi, for example, a couple of years ago, so this is just a couple of years after Harvey, when Harvey was still fresh for them. And the reaction we got and some of the comments that we were able to elicit from them indicated that TWIA has a very serious problem with some of the policyholders. And it is something that Texas Windstorm is acutely aware of. And they've been working very hard to try to change the perception that they are anti-policyholder. And they've worked hard over the last several years, and you will see that the perception is changing about TWIA. Some of you may disagree, but you'll see here in a second. What I hope to do today is to try to demystify TWIA a bit and the claims process for Texas Windstorm. And if I could try to show you how to kind of maximize your recovery, kind of try to show you some suggestions on what you should do and try to maximize the recovery for covered damage or to watch out for certain traps. I had maybe 30 minutes, and I know it's getting late, and so I'll try to get through as quickly as I can, but TWIA wants the same thing all y'all want, which is a fair and honest adjustment that pays fully for covered damages. Let me shake this word. All right, who are we? We are the insurer of last resort. I know some of y'all from Florida. I didn't realize there'd be so many people from Florida. May not be familiar with what we call TWIA, Texas Windstorm Insurance Association. And we're an insurer of last resort, and we were formed in 1971 by the legislature. We weren't called that, but it was formed as a result of Hurricane Celia in 1970, and the insurance carriers began a process of moving from the coast and abandoning the coast and not covering windstorm. So the legislature recognized in order to foment development and continue development along the coast, they needed to provide an insurance carrier. So they created a legislative scheme by which it created an entity, I think it was called the Cat Pool at one time, that would be an insurer of last resort. We are not a private insurance carrier. We were created not to be a direct competitor with the private market, but to instead provide insurance for those who cannot get insurance at the private market. And we are governed by Chapter 2210 of the Insurance Code. What's unique about Texas Windstorm is not only is it not a private carrier, we don't carry a profit, for example, but what's unique is our claims process is actually dictated by the statute. It's very, very important that you know the statute because it'll tell you how Texas Windstorm is supposed to process a claim. It includes when to make a claim. This is not just the policy. This is the statutory. Deadlines for making a claim, deadlines for suing us, how you go about suing Texas Windstorm, deadlines for adjusting the claim and making a claim decision, and what are your remedies and how do you attack the claim decision, so to speak. And we're going to talk about that shortly. But as I said, it's very different from the private market. And so you don't get tripped up. I encourage you to read Chapter 2210 of the Texas Insurance Code, beginning at Section 571 through 576, 78. to familiarize yourself if you're going to get involved with Texas windstorm claims and you're not already familiar with them. As I said, we're a nonprofit. We have no stockholders. We have no shareholders. There's no incentive to deny claims in order to return on equity for any equity holders or shareholders in the company. We don't have incentive plans for our managers, for adjusters. We get requests for reduction all the time. Please provide incentive plans. There's no incentive for that. Whatever profit we make, to the extent that our premiums exceed the amount of expenses and claims paid that day, it goes to what's called the Catastrophe Reserve Trust Fund. And it builds up over time so that when we do have a major event like a Harvey, like an Ike, or some other major hurricane, there will be sufficient funds to be able to pay claims. And in fact, after Hurricane Ike, we had some, between Ike and Dolly, which was 2008, and Hurricane Harvey in 2017, the trust fund had built up to $837 million. Our mission is to pay what we owe timely and with a well-documented file. And if I had to give the best advice on how to maximize your claim, and there'll be little ones a little later on, but it is help us document our file. I can't emphasize that enough. Help TWIA document the file, because we've got to be able to justify what we pay and why we pay, what we cover, and what we pay on the amount of loss that's covered. So send us bids. If you have bids, invoices, take photographs of damage. Record the damage as soon as you can. I'm not talking about just PAs, but any representative of policyholders. Make sure your policyholders do that. And send them Texas Windstorm. And help Texas Windstorm document its file. Because we're graded too by Texas Department of Insurance, and we have to justify why we do what we do. This doesn't mean we're going to agree with you all the time, but it is a conversation. It's the start of a conversation, and hopefully through negotiations we can resolve these claims without resorting to litigation. I don't think anybody wants that, because, well, except maybe the plaintiff's lawyers, but it's to your clients' UPAs, it's to your clients' best interest to try to resolve these claims short of litigation. It makes our job easier if you provide sufficient documentation in our files to be able to justify what we do. Now, Hurricane Ike, to give you some idea, we did not do a good enough job after Hurricane Ike. I knew that would get a laugh. I knew that would get a laugh out of Renee, because we've been in a lot of litigation with the Boston law firm about Hurricane Ike, and that's how I got to know Renee very well. It was tactful. The legislature realized that what had occurred afterwards was not sustainable. It wasn't sustainable for handling claims. It wasn't sustainable for the viability of Texas Windstorm. So the law was changed in 2011 to provide for more accountability of TWIA, dictating exactly what we're supposed to do within the claims process and the deadlines, while at the same time preserving the financial viability of the program. And one of the ways it did that was it eliminated the application of 541 and 542 and bad faith to Texas Windstorm. And that was one of the ways it did. So when Renee talks about suing carriers for here's all the things that I include, they don't apply to Texas Windstorm. As a result of that accountability, TWIA has made great strides in improving its claim handling. There were 95,000 Ike claims. And as you can see, in Hurricane Harvey, we had almost 75,000. That's about 80% of the number of Ike claims. But we did a much better job with Hurricane Harvey. You can see the breakdown of the claims that we received and the resources we deployed quickly to try to resolve the claims with the insureds who really needed it, particularly in the coastal bend area where you did have a lot of wind damage. We had 220 call centers. You can see we had just short of 1,300 field adjusters. And as a result, the average time for payment was 9.1 days from the first notice of loss to the inspection. And then we were able to pay the claim typically on average with 36.1 days. We have 60 days to make that payment. These are all numbers that were better than Ike. We paid almost $1 billion in indemnity, and you can see the average for residential policies. And as a result of that, and always trying to improve what it's doing, Texas Windstorm does surveys and that type of thing of policyholders. And as a result of efforts by Texas Windstorm and hitting the ground quickly and trying to resolve these claims, our TDI complaint rate was significantly lower than it was with Hurricane Ike. You can see at Hurricane Ike, we had about 1.16% of policyholders made a complaint to TDI. I'm not addressing whether TDI actually did anything with them, but this is just the number of complaints that were made to TDI. And but compare that to Harvey, 0.15. And then we send surveys out and ask them to grade on a scale of 0 to 5, how did we do and how are we doing? And you can see in the right-hand column the results. They're all scored relatively high. I don't have my glasses on, I can't read it up there, but it had to do with the appointment. Timely appointment. Was the adjuster professional? Were the customers satisfied with the overall handling? 4.56 is a good result. And what we're seeing is, even in the non-catastrophe claims, the day claims as we call them, as they've continued since Hurricane Harvey, we're seeing very similar results. All right, making a claim. You have 1 year. Now, y'all have talked about deadlines for making claims. Statutory and in our policy echoes what the statute says, as you would imagine, but you have 1 year from the date of loss to file a claim, and that's a hard 1 year. You can get it extended 180 days by the commissioner with good cause. I haven't seen that done, and I only mean from the standpoint I've not seen such a request before, but you can imagine situations where you would need one. For example, someone who is serving overseas in the military and doesn't come back for a year and sees damage that had occurred and says, I need an extension, or someone who works for Aramco or something over in Saudi Arabia and doesn't come back for a year. So be mindful that you can get extensions, but you have a 1 year deadline for making a claim. A claim is defined under our statute that applies to TWIA as a request for payment. And if the policyholder does not make a request for payment regarding damage, then we have no obligation to volunteer a claim determination. Well, what is involved in the claim? Well, this is an ongoing dispute, and quite often, for example, you make a claim for a roof claim. And let's say you make a claim for your roof. You say you're not aware of any interior damage, and then a year later you're tearing in the wall and you see that there's been ongoing leaking from that roof that was repaired, but not as a result of the repairs, but as a result there had been leaking from that roof, and you're just now discovering it. Talk to TWIA, explain the situation to TWIA, and if it's in a gray area like that, TWIA will consider the claim timely. If, however, it comes out of left field, let's say I have a roof claim and I have some interior damage, we go and we adjust the claim, we make a claim decision, and then you turn around and say, oh, by the way, over a year later, I have fence damage. That's probably not going to be covered. And Texas Windstorm will probably make the determination that that is not covered because the claim is too late. Now, what's interesting is that there is a proposal, and Mays Middleton, who's our local representative, he has submitted a proposed changes to the TWIA bill. And one of them has to do with what is a claim. And I'm going to read you the language. This is what's proposed. It's when I looked at it this morning, or yesterday afternoon, the proposed changes and the policy that the proposed bill, is still in the insurance committee and has not been voted out. So I don't know what's going to happen to it. But be aware of this and follow this, because this may result in a change with respect to what constitutes a timely claim. I quote, "For the purposes of this section, an insured is only required to file one claim under an association policy per event. After a claim has been filed, all losses under an association policy for the same event shall be deemed claim, to the extent the insured has submitted information pursuant to Section 2210-573B, regardless of whether such information has been requested by TWIA." And that reference to that Section 573B is simply the one that says that an insured may provide documents and materials and explanations to TWIA with respect to making a claim. So just be cognizant of this bill. and if it comes out and is passed by the legislature and signed into law, that would change all this consideration of whether or not something is timely, whether it's out of left field or whether it's a gray area. But again, talk to TWIA, talk to the adjusters, talk to someone there, and if you think that something is more than a year old but is within that gray area, TWIA will listen and we will consider it's timely filed if it is within that gray area. Investigating the claim. Once the claim is made, TWIA begins its investigation. I'm not going to belabor this. Y'all certainly know it. But keep in mind, our independent adjusters do not have authority to negotiate a claim at the site. They don't have any authority at all. All they are doing is investigating the claim, documenting the condition as soon as they can, as soon as close to the date of loss as they can, and then making recommendations to the desk examiner. The desk examiner is the one who makes the decisions, final decisions with respect to coverage and what is the amount of the loss that is covered by the policy, not the independent adjuster. I would encourage y'all, be a PA if you're representing insured, to be present when the adjuster. You can have someone there. You can have your roofing contractor, a general contractor, or the PA there, and have a conversation with the adjusters. Y'all walk the property together. It makes it easier for us to make decisions if earlier and sooner if everyone is involved in the process early on. We also use experts such as building consultants, which are used to usually are general contractors that help us with scope, help us with material pricing and that type of thing. And of course, we use engineers to help us determine causation if there's any real question regarding causation. So after all that's done, TWIA makes a claim decision. It's a little different than other carriers, than your private carriers. Within 60 days, we have to make a claim, a decision with respect to, after the first notice of loss, 60 days, whether or not we're going to cover the claim damage. Is there coverage? And if there is coverage, what amount, what's the value, what's the value of the loss? If TWIA requests information, we get another 60 days from receipt of that information. So the claim decision is going to be one of three things. It's going to be we're either going to fully accept the claim, fully accept coverage for the claim, fully deny coverage for the claim, or a combination of partially accepted and partially denied. It's important to understand those distinctions because it dictates your remedy. The claim decision will be a letter that will address what damages are accepted, if any. It'll tell you, it'll list the damages. It says how much we will pay for the accepted coverage, accepted damages, what damages, if any, are denied, why those damages are not covered, what damages we observe but were not claimed, and if necessary, what damages are still being investigated. And in other words, the claim remains open. Remember that our coverage decision is made as to the damages presented, not to repair methods or dollar amounts. And that you've got in that distinction between coverage and claim is important. There are actually some case law I'm going to talk about at the end that makes the distinction between coverage, and claim. A claim is a request for money. Coverage is whether or not the policy covers that claim, those damages. And so the damages observed. If you look at I don't have an example of the claim decision letter. I think some of you all probably seen it, but there's usually a section that says here are damages that you have that are not claimed. And the reason we do that is because we don't want to waste time and resources adjusting something that everyone agrees is not part of the claim. But we also list it so that, again, public adjusters, whoever the representatives of the insureds are when they get these letters, look at that list, and if you disagree with something that's on that list as not covered and not claimed, call up the adjuster, call up the desk adjuster, unless it's in litigation, call up the desk adjuster and say, no, this is a mistake, this is part of the claim. TWIA will then make a claim decision with respect to that additional damage. And we may need to send someone back out, but it will be addressed. So I encourage you to do that. TWIA has 10 days from the decision letter to pay the claim. Quite often the check will actually accompany the decision letter, not always, but also often does. Now, as I said, there are accepted claims and there are denied claims. You cannot sue TWIA for the accepted claims. Your only remedy to challenge the amount that Texas Windstorm places on the value of that loss is by appraisal. And it's incumbent upon you to incumbent upon the insured to invoke appraisal within 60 days of the receipt of the decision letter. The process starts when you invoke it and you name your appraiser, and it's incumbent upon the insured to name an appraiser. We don't name an appraiser until the insured names the appraiser. And what often happens is Texas Windstorm, no one wants to go to appraiser, they don't have to. It's expensive. The insured has to share in the cost of that, and that ends up simply reducing the amount of recovery by the insured. So both sides have an incentive to try to avoid appraisal. But you still got to invoke it within 60 days of the receipt of the decision letter. So what TWIA often does is they will contact the insured or the insured's representative and say, do you want to abate appraisal? Or the insured can request that appraisal be abated and continue to discuss the claim. And I encourage you all to do that. Continue to discuss with the claims examiner. Again, you want to document their file. If there's any additional invoices, bids, whatever you need to send, try to negotiate the claim without having to go to appraisal. And at some point, you may have to go to appraisal. Something that's not often caught, co-insurance penalties. The co-insurance penalty, I think y'all are familiar with. Under Texas Windstorm's policy, the property has to be insured to 80% of value. And if not, if it's below 80%, then a penalty can apply. It's a very complicated formula that's actually in the policy, and I don't pretend to understand it or pretend to be able to recite it. But there is a formula that they use. And you will see sometimes claim decision letters that will look like this. We've determined that the building is underinsured. Now, this is, again, if we accept coverage and there's a co-insurance violation, then the penalty will apply, and it explains the application of the penalty and how they did it. Is there a way to back this up? The red button. All right. So this is from our policy. If TWIA assesses a co-insurance penalty, the insured can only dispute this through appraisal. So if the co-insurance penalty can only be disputed through appraisal. So if you get a claim decision letter with a co-insurance and you dispute that value, be sure you ask that the appraisers appraise the value of the building or the home, and that's actually what the appraisers will be doing. For example, in this example here, this is an actual claim decision letter that was culled from, but you can see the building value was $117,144. That probably came from a Marshall Swift Beck calculation. And so at 80%, they're required to carry some almost $94,000 worth of coverage, and you can see that the actual building limit was $51,000. And the result of that was to reduce their amount of loss from $38,000 less the deductible. The amount that they can recover was actually reduced almost in half to $19,867. This person did not, when they invoked appraisal, did not ask that the co-insurance, that the value be appraised. And that's what the appraisers would actually be doing, is appraising the value of the building to see whether or not the co-insurance penalty should apply. So, hint, hint, if you have a situation where you have this and you do invoke appraisal, then make sure that they also appraise the value of the home if the co-insurance penalty applies. RCC is, of course, is the depreciation that's withheld. Not all depreciation is recoverable. Here's a hint on appraisal. Here's something to consider. Sometimes you have a situation where you invoke appraisal, you go to appraisal, and the award is issued, and of course the award is binding, and now you go out and you do the repairs, and what happens? The repairs end up being more than what the appraisal award is. And so you want to try to recover as much as the depreciation you can, and even the depreciation value is locked in. And now you're stuck. So again, you've still got to invoke appraisal timely. But my suggestion is that if to invoke the appraisal, abate it, continue to discuss to the extent you can on trying to resolve the differences in what you think the value is. Do the repairs. Go ahead and do the repairs if you can afford to. I realize that not everyone can do that. The fact that we're talking about appraisal means that we accepted the coverage and made some payment typically, although sometimes it's below deductible. But invoke appraisal, abate it, do the repairs, then take the invoices and provide the invoices to the appraisal panel, and then appraise. Because once it's appraised, it's locked in. So that's just a suggestion to try to maximize the amount that you could possibly recover. Sometimes the appraisal award doesn't come back like you think it is. We do have a case. I don't have my glasses. I don't know if Chris Lackey's in here. He and I were just talking about it. It's one that he's involved in which, unfortunately, the information that was provided does not break out sufficiently what was upgrades and not. It was very difficult. So went on to appraisal. The appraisers were not able to really tell from the invoices, and the award ends up being less than what was paid. But now it's locked in. I realize it's late. Supplements. Request for additional payment for the same damage. This is not addressed by statute. The statute is about claim processing, but in reality, it's really about claim adjusting. And TWIA's goal is to ensure a complete and thorough investigation while preserving everyone's right. And if we follow the statute literally, then every claim is typically a one-shot deal, if we follow it literally. You have policy presenting exactly what they want. We accept coverage, determine a payment, and then it goes to appraisal if the insurer is not satisfied. We don't think that's fair to anyone. So Texas Windstorm has come up with a solution for supplements. If a supplement request is made within the deadline to request appraisal, again, that's 60 days, then we will consider it and provide whatever information. We'll consider the supplement, and we will issue a new claim decision letter on whether or not we accept it in whole or in part, the supplement. And once we issue a new claim decision letter, all the deadlines start running again. There are new deadlines. Here is typically what these second and third and fourth claim decision letter. We've had some files that have 5, 6, or 7 claim decision letters. If you've received a previous notice of claim acceptance, denial, or acceptance in part and denial in part, this notice replaces the prior notice, and the deadlines to dispute coverage and payment determinations begin with the receipt of this notice. So all your deadlines start over. All right, so that's, again, if the claim is accepted, your only remedy to contest the value, the amount of damage is through appraisal. If we deny a claim, you can sue us. And so here are the deadlines for filing a suit. You have 2 years. This is statutory, not just in the policy. It's statutory. You have 2 years from the receipt of the decision letter to file a suit. Notice it's not from the date of loss. It is when you receive a claim decision letter. And keep in mind, quite often we issue multiple claim decision letters, and with that language it says, ignore the others, everything starts from here. So quite often that'll end up pushing your 2 years back. The second one is very important for those who are not familiar with the statute. You must provide a notice of intent to sue within 2 years of receipt of the claim decision letter. This is not just in the policy, it's statutory. It is jurisdictional. We had a situation here in Galveston. It was a case of mine in Judge Ellisor's court in which I can only guess that the attorney, time was running out, and on the second anniversary of the storm, the second anniversary of the claim decision letter, he filed lawsuit and to try to beat limitations. And I guess he thought, and there is a provision in there, that if time is running late, it's kind of like DTPA, time is running late, you can file your lawsuit. You're still supposed to give us 60 days. And if you haven't given us 60 days, you can abate the suit while you give us the proper notice. However, the statute says you must give us notice of intent to sue within 2 years of the receipt of the claim decision letter. I guess he thought he could still do that by simply filing the suit. You can't. The fact that he did not give us notice of intent to sue within that 2-year period was jurisdictional. We filed a plea to the jurisdiction, and it was granted, and the case was kicked out. It did not go on appeal, so this has not been adjudicated at a higher level, but you all don't want to be in that position. So be sure you always send a notice of intent to sue prior to filing suit. Renee was talking about in her cases, she always sues the IAs and does this, et cetera. You can't sue the independent adjusters in TWIA cases. And frankly, I haven't seen anybody do that in 8 years. So I think the message is out there, and the language comes from here. You cannot sue the agent or representative of TWIA. The independent adjusters are not our agent, but they are representatives of Texas Windstorm. So you cannot sue them under DTPA 541, 542, and more importantly, this subchapter is the exclusive remedies against TWIA, including its agents or representatives. And as I said, fortunately, no one is suing the adjusters. You can't sue us for bad faith under 541 or 542. It's statutory. One of the issues that is currently on appeal in a case I've got, it's going to the Supreme Court, although I don't think this is one of the issues that's actually going to the Supreme Court, we have taken the position is, since these are exclusive remedies, you cannot sue us for not only for 541, 542, DTPA and that, but you can't sue us for breach of good faith and fair dealing. You can't sue us for fraud or anything like that. So your remedies are exclusive. You need to understand the statute before you sue us. All right, a couple cases, and I'm done. I'll be done. Grief? Sure. I would expect nothing less. Well, usually Right. Well, I disagree with that characterization for this reason. We're not using more building consultants as adjusters because every claim starts with an adjuster. So in every claim, it starts with an adjuster. And then if there's a dispute that goes on, what usually happens is it's an engineer and building consultant go out there. So the engineer will go out there and make decisions regarding whether or not it's coverage or not, whether this is covered or not. And if it is, then the building consultant does the estimate instead of the original adjuster. So, okay. And I'll have to take your word for it. I have not seen that in any of my cases ever. Sure. Call the claims examiner and point it out, and we'll issue a new claim decision letter. It's we're trying to avoid. I think everyone wants to try to avoid litigation if they can, and so it's an ongoing conversation. And just if you just call the claims examiner. I mean, I can't answer for every situation, but. This assumes it's not in litigation, obviously, and before a lawyer's involved, but you call the desk examiner directly. Yes. Sure. And I think everyone would agree, those who've been doing this for a while, that our claims decision letters are getting more and more detailed. I mean, we're continuing to learn. And we're going to talk about this Randy Jones case here in a minute, but so if there's something that seems to be omitted and is not addressed, I've seen them, and it does concern me. I'll say that. And sometimes you will end up seeing a new claim decision letter when the litigation examiner realizes this issue was not addressed, and so they'll make that decision to address it in another claim decision letter, which does what? Starts all the deadlines over again. I agree that does occur. That does occur. So it's important to know this Randy Jones case and write the site down and read it if you can. There's a case that came out of the Houston area, and I think it was in Angleton. In fact, I know it was in Angleton, Brazoria County. Made a roof claim. TWIA sent a letter, says we accept coverage for the roof. But what we paid for was like 10 or 12 shingles. And so we were sued under the theory that, wait a minute, you didn't pay for a full roof. You only paid for 10 or 12 shingles. That is an implied denial of the remainder of the roof. And we appeal, so it went up on appeal ultimately, and the court issued this opinion that talked about how the plaintiffs, the insured, conflated the idea of coverage and claim. A claim is a request for payment, but coverage is whether or not the policy covers that claim and will pay for the request for payment, the claim. And what TWIA did was made a coverage decision. It was accepted. And if you look at the statute says for any accepted damage, then your only remedy is appraisal. And they did not invoke appraisal, so they were without a remedy. The fact that it was 10 shingles versus a full roof is a scope issue on having to do with the amount that we will pay. And so the remedy was appraisal, which was not utilized. No. It said we accept coverage for the roof. They provided payment. Whether or not, and I don't remember off the top of my head, this particular case was not mine, the next one was, but I don't recall whether or not, for example, the estimate was appended to it, or if that would have even made a difference, though. So, and yeah, right, and that's what it did. And so the Park case rose from Hurricane Harvey. It was in Aransas County, and it also, now the insured said, look, this was a total loss. I mean, it was bad. There was a lot of damage to the house. There's no question about it. And they thought it was a total loss. He and his counsel thought it was a total loss. And so Texas Windstorm puts a value on it, which was quite a bit less than policy limits, less than a total loss. And so they sued us. And we filed, and the decision letter said, we fully accept your claim. Here's what we're paying. We're paying $100 and something thousand instead of $300 something thousand. And so their position was, well, wait a minute, you're not paying us for a total loss. Here is our estimates and everything that shows that this was a total loss. And using the Randy Jones case, the Court of Appeals in Corpus Christi, which tends to be a little more liberal, liberal than most, citing the Jones case, said you're conflating coverage with claim, amount of payment on the claim. So, if it says a fully accepted claim, you need to invoke out a bunch of caution. Don't just think, okay, you impliedly denied, and I think the implication is from all that there is no such thing as impliedly denied. And if you need clarification on your claim decision letter, again, please call the desk examiner and say, I'm confused about this, this was omitted, etc. Here is, for example, now compare that, the Randy Jones, with this one. TWIA accepts all damages as detailed on the enclosed estimate. Now, sometimes you'll see this, and particularly later on. Wind damage to ridge cap shingles denies the following: damage to your roof other than the ridge cap shingles. Now you can sue for everything except the ridge cap shingles, and that's different than the Randy Jones case. Yeah, you told me I could go to 5, so let me just say something real quick. There are 2 other cases to keep an eye on, right, that are circulating in the courts of appeals. I don't have them up. One is called the Boys and Girls Club of Coastal Bend, and this was a case I had that the issue that is now going before the Supreme Court. Well, there were 3 issues. One is that was near and dear to the plaintiff's attorney. They filed a lawsuit before they gave us notice, but still it was within a year, so no harm, no foul, or within the 2-year limitations. And so the case was abated for the 60 days, and we went to mediation. We had accepted coverage for most of the roof of the Boys and Girls Club, but denied it for one big roof. We went to mediation. They provided new information. We're always reassessing a claim. You always give us information, give us documents, and based on our assessment of this new information, 2 days later, we accepted coverage of the roof. Now, the case is already in litigation, and so they thought they were entitled to attorney's fees. We filed a plea of the jurisdiction based upon our acceptance of that, and which gets rid, and they said, well, wait a minute, what about our attorney's fees? So that, and the Court of Appeals said, sorry, TWIA is not precluded from later accepting coverage, and you are not entitled to attorney's fees. Now, it's kind of a fact-specific case because we actually accepted the coverage within that 60 days, and they shouldn't have filed the lawsuit to begin with, so whether or not that makes a difference in any subsequent, I don't know. The other issue was Randy Jones' case, which was out of Brazoria, was decided based on a plea to the jurisdiction. It was granted. So it was based on a plea to the jurisdiction, which means the issue of acceptance of coverage is jurisdictional. If we accept coverage and we say in our statute you can't sue, is that jurisdictional? The Corpus Christi Court of Appeals disagrees with. They said that it is not jurisdictional, that jurisdiction is proper to consider that. However, we're granting your summary judgment because it was accepted and you can't sue for that. But it's not jurisdictional. So actually the issue that Texas Windstorm is taking up on appeal is, even though we won the appeal in the Corpus Christi Court of Appeals, we want a decision on whether or not you can sue us in appraisal. Is that a jurisdictional issue? And so you've got a conflict between the 2 courts of appeals. Another case that's interesting, again, it's another case that I tried, was a case called Valstay. And I think Rob Lurie and Todd Lipscomb is, I know they're on the other side. Lurie and Lipscomb are on the other side of this case. One of the issues is a little more complicated, but to reduce it to something simple, this was a case in which there was a specific date for a hail claim and a wind claim. And there was no question that there was wind damage. There was a question whether hail damage. There's no question that there was wind damage. And we denied coverage. And we go to trial, and it begins with these 2 specific dates. And then something happens at trial, and they begin to realize, this date really doesn't work. However, based upon pictometry, you could tell that the damage existed on a certain date and didn't exist at some other date. And the first date where it didn't exist was well before the 1-year deadline for filing a claim. And the other date was within the 1-year deadline. So when it went to the jury, because there was no specific date, the judge agreed with me that all the evidence that they had produced had to do with these 2 dates. It went to trial and went to the jury with that. The jury said, no, there was no no coverage. Texas Windstorm's exonerated. Their argument is that the jury charge should have simply charged any damage within 1 year, but shift the burden to TWIA. They want to put the burden on Texas Windstorm to prove it did not occur during the 1-year period. So that's an interesting case on how that may resolve, and it may have some impact beyond Texas Windstorm, I don't know. But it's called Valstay, V-A-L-S-T-A-Y, and we have argued the case a couple months ago, I guess, but we're still waiting on a decision from the Corpus Christi Court of Appeals on that one. I don't know the site off the top of my head. But I know that y'all want to do something at 5 o'clock. There's my number. You're free to call me. Yes, yeah. No, no, there's not an exclusion. I mean, it's either, their argument is that, look, there is windstorm damage. I mean, our guys went out there and said there is windstorm damage, but they placed it before the date of loss. And their argument is, when it started to fall apart at trial, their argument is, look, all we have to show is that there was damage, and it's covered damage. Windstorm is covered, and we had a policy in 2000, whenever this was, for several years before as well. So we know that at some point when we had coverage, this loss occurred. And we realize there's a one-year deadline, but the burden is on you, and I guess you'd call that exclusion, yeah. The one-year exclusion, so to speak, that if you don't bring a claim within 1 year, you're out. They want to put the burden on Texas Windstorm to prove that it did not occur during that 1 year, instead of their proving it did occur during the 1 year. So we're kind of anxiously awaiting that one, because that's a dynamic change. That's my office number. Call me if you have any questions. Thanks for your patience.